Hello everyone, we hope you're doing great. Welcome back to another Canada Immigration Guides informative video. Today, we'll be looking at Bill C19 new changes. Remember to hit that subscribe button to stay updated on the latest news about Canada immigration. So, without further ado, let's get started. The express entry system underwent several changes as soon as the Royal Assent was given to Bill C19. The comprehensive ranking system, which is used to evaluate and rank the individuals in the pool, will undergo changes due to these new amendments. A portion of the Provincial Nominee Program, the Canadian Experience Class, the Federal Skilled Worker Program, the Federal Skilled Trades Program, and another component of the Federal Skilled Worker Program are some of the major economic immigration categories included in express entry. In 2023, the Federal Skilled Worker Program and the Federal Skilled Trades Program will undergo changes due to Bill C19. Another area that will be affected is the expression of interest process, which chooses candidates with the highest rankings based on regularly released instructions from the ministry. These applicants are contacted later and invited to finish their immigration applications. Now, let's look at a summary of the amendments to the express entry system and fee waivers for some IRCC applications included in Bill C19. This will assist you in getting ready for the upcoming changes. This new information regarding groups and categories will now be considered during the express entry selection process. The up-to-date amendments will include ministerial instructions to add additional filters to the express entry pool based not only on immigration class but also on groups and categories. These filters will be based on a combination of immigration classes and the groups and categories. The ministerial instructions will serve as the basis for the various invitations that will be extended. Applicants for express entry ITAs must specify the express entry stream for which they wish to apply. A further modification is the introduction of new categories, each of which has a specific eligibility requirements for the purpose of ranking. If a foreign national meets the requirements for more than one category, the invitation to submit an application for permanent residence should state which category the applicant must use when submitting their application. The minister is to identify a particular economic objective for each category. The newly introduced amendment also stipulates that the minister must identify within the instruction the economic objective that will be advanced by the newly created category. Applicants who have scored lower due to their age are still eligible to receive a visa as permanent residents. The amendment creates exclusions that make it possible for candidates who have been invited to apply for a visa through express entry but who, in the absence of the amendment, would have lost eligibility due to changes in their circumstances to be granted permanent residence visas through express entry. Take for instance, the scenario in which an applicant has aged, suffered a loss in points, or been disqualified but has managed to keep their score at the same level as the minimum required to rank in the invitation round. In that case, they might be given a visa or other documents to travel with. The report of the minister will include an established category for international citizens. According to the amendment that was added, instructions to establish any category for foreign nationals in express entry must be included in the annual report that the minister must provide to Parliament. These instructions need to include the economic goal that they are helping to support, as well as the number of invitations that have been issued under this category. In the coming months, additional information regarding Bill C19 and the newly defined categories and eligibility requirements will be made public. Alterations to various fee structures as provided for in Bill C19. Typically, regulations are outlined in the Canada Gazette, and immigration fees are also published there. However, before adjusting to the fees associated with immigration, the government must conduct a regulatory impact analysis and solicit feedback from interested parties. In addition, the Service Fees Act does not apply to the processing of applications for a non-permanent resident visa, a citizen visa, a permit to work, a study permit, an extension of an authorization to remain in Canada as a temporary resident, or an authorization to stay as a permanent resident in Canada. This is because the Service Fees Act does not apply to these applications. Other service fees, such as those related to processing applications based on humanitarian and compassionate considerations, are not subject to the exemption. Among these are services associated with processing applications to sponsor members of the family class and services to obtain travel documents for permanent residents, including permanent resident cards. As a result of Bill C19, there are a couple of newly introduced service fees which will no longer be subject to taxation. First one is permission for a Canadian citizen or permanent resident to return to the country, rehabilitation to determine criminality and serious criminality, and lastly is the restatement of temporary status and issuance of temporary residence permits. What are your thoughts on this? Let us know your view in the comment section below, and we'll see you in the next video. Bye!